है मुश्किल जीना यहाँ, जरा हट के जरा बच के, ये है बॉम्बे मेरी जान।
Well, I'm a practicing advocate in Bombay High Court, Bombay City Sessions Court. I also practice in the Supreme Court. I joined this particular profession on the 28th of June, 1984. And it's nearly about 37, 38 years that I have put inside in this practice. I inherited the practice from my late father. He was practicing in the same courts since 1956. Until 1984, when he passed away, and I took over the practice from him. Now, by the grace of God, I have my son also working with me. My son practices with me in the last 11 years. I have a team of almost about 32 people, and we're practicing essentially criminal law, but my son was always inclined towards civil law, so he's doing civil practice also. We're having arbitration matters, we're having civil matters, suits, writ petitions, criminal matters. And I'm enjoying my work because now this work is no more work for me. It's a passion which has become. It's become a passion for me. So, because of the lockdown and because of COVID, we've been held back at home for months together in the form of a lockdown. So now I've started to miss my work. But virtual courts are indeed a blessing in disguise. In the last lockdown that we had in 2020, from March 2020 onwards, I had an occasion and an opportunity to do something which I had not done in my 37 years. In one day, I was able to appear in the High Court and the Supreme Court, which is in Delhi, at the same time. So in the morning, from 10:30 onwards, I was before the Supreme Court. I did my matter there, finished the matter, switched over to the website of the High Court and appeared in the High Court. Now, these virtual courts are certain things which enable you to practice in multiple courts. So in a day, if I have a matter in Punjab and Haryana High Court, I can switch into their website, I can appear there, which is humanly impossible if you have physical courts. And of lately, our Supreme Court judges, Lordship Justice Dhananjay Chandrachud, has taken tremendous interest in virtual courts. The legal fraternity is also happy with virtual courts, but some lawyers feel that they are not up to the mark as far as the technology is concerned. So they want physical courts. So I personally feel that the day may come where we will be having hybrid courts. Certain days it will be physical courts, or certain matters will be physical courts, and certain matters and certain days, or certain matters and certain days may be in the form of virtual courts. In the virtual court also, you have the same mode of appearance before the court. The judges are on virtual mode with you. They are presiding in the court. We have a virtual conferencing system installed in the court, one of the finest. I'm on this side. My opponent will be on VC on the other side. So I'll be arguing my matter, he'll be arguing his matter. The judges are going to hear us exactly what I would have otherwise argued in open court. The only drawback which I personally feel which may interfere in the performance of the lawyer is not the physical presence of the lawyer in the court, but a regular streamed proper network bandwidth, which unfortunately has to be bettered in the courts. We need to have a better system. These are basically the problems you have, the teething problems that you have when you start something new. And slowly and steadily, I'm confident that we'll be able to overcome it. We'll be having a dedicated bandwidth and a dedicated network with which we advocates will be able to make appearance in the virtual courts. So virtual courts are definitely a blessing in disguise. You can appear, you can widen your scope of appearance. You can go to multiple courts, multiple tribunals at the same time on one particular day by switching from system to system, system to system. And I'm very savvy with the system and with the technology. So I have no problem. So I'm addressing you based on what my feeling is. But there may be another colleague of mine who may feel that no, he is better up with the physical hearings. So it depends from person to person. But yes, virtual courts will never in any way affect the hearing of the matter, the performance of the lawyers, and the result by the judges. The judges are going to hear the same matter which they're hearing me in physical court as well as in virtual court. So they're going to be giving me a particular finding and based on what I argue and based on which my opponent argues. It depends whose case is a better case. So it goes according to that. My first case was criminal writ petition number 73 of 1984. It was a Coffeeposa writ petition, which was filed for quashing of an order of detention issued under the Coffeeposa Act. And incidentally, that particular writ petition was drafted and filed by me when my father was alive. But unfortunately, he passed away. And then the matter was listed before the division bench of Justice P.S. Shah and Justice Puranik. And that was my first appearance, 28th of June, 1984. I went to the Bar Council, picked up my license, my sanad, went straight to the court, argued the matter, and touch wood, with the blessings of God Almighty and the blessing of my parents, I succeeded in that matter. So I opened up my innings with a success. Yes, I have worked upon homicide cases. There are some which are still pending. And it all depends from facts of case to case, you understand? And it's interesting, but sometimes you have to be, you have to be very careful. When you're doing a homicide case, there are three options. Either he gets acquitted and he goes home, or he goes in jail for life, or he goes to the gallows. If he goes to life, it's very good. If he goes to life, if he goes home, it's very good. If he gets a life sentence, you will definitely feel upset, client will be upset. But the most important thing is you have to see and you have to ensure that it doesn't go to the gallows. Because that is going to be sort of stigma on your career for years to come. And I would definitely not be wanting to be held responsible for sending any particular person to the gallows. So I am very, very cautious and careful even to accept such a case. I go through the charge sheet. I have a big team. I give the charge sheet to my other team members also. Let them also go through the charge sheet. And based on what our group discussion takes place, and then we decide whether at all we should accept this brief or not. If I feel the brief is so bad, the facts of the case are so bad, that there is no chance of, saving him from going to the gallows, then I don't accept the brief. See, there have been certain trials, which, for example, in the 93 blast case, we used to conduct the trials from 11 o'clock in the morning, sometimes till 6 o'clock in the evening, which is 1.5 hours beyond our court timings. So by the time it finishes at 6 o'clock, I reach my office at 6:30. I never used to get time to prepare for the rest of the cross-examination. And since the case was a matter of great responsibility, it was not a very, it was not a cakewalk. It was a tedious task to do the trial. Multiple witnesses, CBI officers were witnesses, officers of crime branch were witnesses, senior officers from Gujarat Police were witnesses. There were witnesses from the government department, bureaucrats. It was not very easy going through this entire rigor of the cross-examination. So I used to either sit in the office till 2 o'clock in the morning preparing my cross-examination for the next day, or I used to carry it home and then sit in isolation at home and study that particular brief, and then next morning continue the cross-examination. That particular accused with whom I was defending, he was ultimately convicted in the 93 blast case. We can't take names right now. And the order of conviction remained, but the sentence could not be pronounced by the learned judge because the next day after the conviction was granted to the accused, he passed away. in the jail. Yes, he passed away, so there was no sentence as such. That order of conviction was there, but sentence could not be given to him. We were told that he got a heart attack. He was a cardiac patient. You know, the blast had taken place on the 12th of March 1993. And it had taken place on multiple places in Bombay. It was a case of conspiracy. Conspiracy, according to the prosecution, was hatched overseas. Number of people within Mumbai city, within India, different states were involved in that particular conspiracy. The initial investigation was taken over by Mumbai police. Thereafter, the investigation was transferred to CBI. So CBI continued with the investigation. Certain charge sheets were filed by the police, certain charge sheets were filed by CBI. But ultimately, the entire trial was conducted by CBI and the special public prosecutor appointed by CBI in the special court of the designated judge. Initially, the trial was conducted before a special designated judge, His Lordship Justice Kode. And thereafter, we had other judges. But then the last judge that we had was His Honor Judge, I forgot his name, excellent judge, Sanap, His Honor Judge Shri G. Sanap. And he conducted the remaining of the trial. It was a marathon trial, marathon investigation. The charge sheet ran into more than 7,000 pages. So from that, you have a fair idea of what sort of investigation and what sort of efforts must have been put in by the officers in the investigation. There were a number of confessions which were recorded. Those confessions were recorded by the police before the Deputy Superintendent of Police. Some were recorded before the magistrate. There was a lot of investigation which was done outside state of Maharashtra. Some was done within state of Maharashtra. Because apart from the bomb blast, there was also the conspiracy of landing of weapons, landing of RDX. So one particular place, RDX was landed. So investigation was done there by the local police and Bombay police and CBI. Then there was one particular place where the weapons were landed. Weapons were seized. The weapons were brought to the court for the purpose of trial. And we had an occasion to handle those particular weapons during the course of investigation. So giving a lawyer a pen is different from giving him an AK-56. So to know how the weapon functions, I was overseas for some time and therefore I took a small course in ballistic science. Ballistic science essentially is related to weapons, firing of bullets, and the forensic examination of those particular exhibits. Because of a little bit of experience that I got from that particular line of education in the US. So I was able to cross-examine those particular ballistic experts. My cross-examination was for almost about 180 pages. And it went on for more than a month. And I enjoyed it. It was indeed something new for me. Dismantling the AK-56 weapon, joining it again. Everything was going on in the trial. And then the trial was in 2 or 3 parts. The first part was by His Lordship Justice Kode, where a number of people were convicted. Some were sent to the gallows, some were acquitted. Then we went on changing of the designated judge, because His Lordship Justice Kode was elevated to the Bombay High Court as a High Court judge from where he retired. So we had different judges coming in. And till today, their entire trial is not over, because there are a number of more absconding accused persons. Some of them are still in custody. Their trials are yet to commence. They've not yet started. And there are some absconders who are still overseas. If they are brought to book, then investigation will start again. Their charge sheets will be filed again, and then the trial will proceed. See, as a lawyer, the judicial system only lacks in quick disposals. Because on a daily basis, thousands and thousands of cases are filed. Every High Court has two sides. One is the original side, one is the criminal side. On each side, you have thousands of cases which are filed. Property disputes, commercial disputes, arbitration matters, family court matters, criminal matters, bail matters, appeals, revisions, writ petitions. The scope of legal practice is very wide. Because of so much of filing, you need quick disposals. The quick disposal is possible only if the government takes it up seriously in their hands to ensure that every high court in the country has a full strength of appointed judges. Until recently, we were only occupying, say, 50% of the strength of the Bombay High Court. Then slowly and steadily it started increasing. But still, there are vacancies. There are yet appointees who are required to be appointed. The moment they are appointed, then maybe you'll find a speedy disposal of cases and expeditious disposal of cases. Plus, the investigation nowadays has become so detailed. The preparation of filing of the charge sheet by the investigating officer is so vast, running into pages and pages. Now they have a lot of forensic examination. They have electronic evidence being collected. So collection of evidence in the form of electronic mode requires certain preparation before submission of charge sheet. So when all this accumulates, you need a number of judges to deal with such matters and dispose it of. We have special courts in the trial courts. For special acts, we've got special courts. For example, if you say the Prevention of Money Laundering Act, it's a special act. There are so many cases, one judge. If you find CBI cases, one judge, multiple cases. Anti-corruption court, one judge, multiple cases. So you need more judges being appointed. For example, if you have PMLA, you need at least 3 or 4 judges dealing with only PMLA. That is money laundering. Then you have anti-corruption, you need multiple judges. You have CBI cases, you need multiple judges. Otherwise, there's going to be no disposal. This is the only drawback of the judiciary, of the judicial system, I should say. I can't say judiciary, because if I say judiciary, that means I'm pointing to the judges. Judges are not responsible. We have certain judges. His Lordship Justice P.D. Nayak. He was first a member of the legal fraternity practicing law, then he went and joined the bench. Then he was appointed. During the lockdown, the learned judge used to sit till 8 o'clock in the morning, in the night. He used to come in the morning at 10:30 or 11 o'clock. He used to sit till 8:30 in the night. The longer he sits, the more disposals there are. And he used to give excellent disposal on a daily basis. We have Justice Kathawala. He has made us work in the night at 11 o'clock also. I have appeared before him in the night at 11 o'clock in his chambers. And in the night at 11 o'clock, his courtroom outside, the corridor outside his courtroom and outside his chamber used to be packed with lawyers. So we have some of the best judges. But just 2 judges sitting up till 8 o'clock, 9 o'clock, 11 o'clock, it's not sufficient. And you can't expect every judge sitting up till 9 o'clock and 10 o'clock. Your time begins at 10:30, 5:30, 5:30, 5:30. You retire to chamber. There's a lot of administrative work which a judge is required to do. If he gives dictation of a judgment, before signing the judgment, he has to read the judgment. Not once, not twice, sometimes thrice. So there should not be any mistake. Because if a judge makes a mistake in the judgment, he signs it. That mistake becomes a law. So you need to be very, very careful. Judges have got tremendous pressure, tremendous responsibility to see that the law is correctly developed. We do that in a number of trials because when we go to the charge sheet, we take instructions from our clients. Based on the instructions of the clients, we are supposed to chart out a course of defense. Sometimes it's easy by going to the papers that we chart out a defense. But sometimes the nature of documents filed in the charge sheet are so confusing. For example, the Panchanama at the scene of offense. Okay. Officers, when they make the Panchanama, they tend to exaggerate a lot. You understand? Sometimes they make genuine mistakes. So if you go to the site and to the scene of offense, you see the site and the scene of offense. There are two advantages. Number one, you are able to assess the document effectively. And number two, you are able to test the veracity of the document by cross-examining the witness. If he is not conversant with the area, with the scene of offense, and in law, they are supposed to prepare a plan in respect to the scene of offense. That is a part of the police manual, that you're supposed to prepare the scene of offense, how it looks, the entire topography, as we call it. If the officer is not conversant with the topography of that particular area, then we can suggest to the judge that this particular witness was not present on the spot. That is a line of my defense. So at the scene of offense, when we visit, there are multiple issues which arise, which we can use for the purpose of cross-examining the witnesses. So I don't know what others do, but I definitely make it a point to visit the scene of offense. If I'm not able to do it myself, I make my team go, my associates go, my juniors go. They make notes, they take out pictures, video, etc. And then based on that, we conduct trials.
So looking back, how has your journey been so far?
Very exciting. 2 words, very exciting. And I don't think anything else would have given me so much of satisfaction as this legal profession has. And this is obviously, it was destined to be my profession. Otherwise, when my father was unwell, I was planning to go overseas for doing MBA to the US. And my younger brother was planning to do law and get into the civil side of practice. But as fate and destiny would have it, my father's physical condition was very, very weak after his second attack. And the doctor said that his heart is very weak, anything can happen anytime. So that is when we switched. He went overseas for MBA, I got into law. But I got no repentance. God has been very kind. My parents were always there to bless me. Allah is there to have blessed me. I'm very happy. And as I told you, now it has become a passion. It's no more a profession. And the scope of work has increased a lot. In the last 37 years, we've seen how law has changed. We've seen how lawyers have changed. We've seen how the mode and manner of commission of an offense has changed. Now there is a lot of white-collar offenses being committed. You have the dark web. So you don't know who's sitting behind the curtain and committing the offense. If he is caught, then to prove that or disprove that is a different ballgame altogether. It's not something which I can do on my own. I need to take the assistance of a technology expert who is conversant with the law of information technology is coded. It is there in the form of a Bare Act. Sections are there. I will read that and I will apply that. But behind that, behind the curtain, what he was doing, whether he was doing was something wrong, was not wrong, is something which I have to deal with in court, which I can't do all alone without any assistance from a technology expert. So we have forensic experts now. So we take the assistance of forensic experts and keep them present in the court so that in case if I make a particular mistake, he can tug my coat and say, don't ask this, ask this. See, if it's a new subject, you should always accept that you're not a master in that and don't try to portray that you're a master in that and make a mess up of the case. So you have an expert sitting next to you, a forensic expert, take his assistance and then proceed with the trial.